In the harsh reality of armed conflict, where destruction often seems limitless, there are still boundaries. There are tools of war that are considered simply too horrific, too indiscriminately cruel to ever be used. International humanitarian law, often referred to as the laws of armed conflict, indeed prohibits specific weapons that are deemed to cause unnecessary suffering or to be inherently indiscriminate. These prohibitions aim to mitigate the brutality of war by restricting the means and methods of warfare. The prohibition of certain weapons stems from fundamental principles of international humanitarian law. These include the principle of humanity, which aims to prevent superfluous injury or unnecessary suffering. A weapon is unlawful if it is designed to cause harm disproportionate to its military advantage, or if it causes suffering that is not militarily necessary. Another crucial principle is distinction, meaning weapons must be capable of distinguishing between combatants and civilians, and military objectives from civilian objects. Weapons that cannot make this distinction, or whose effects are inherently indiscriminate, are prohibited. Historically, the Martin's Clause, a foundational concept in international humanitarian law, reminds us that even in cases not covered by specific treaty provisions, civilians and combatants remain under the protection and governance of the principles of the law of nations, derived from the usages established among civilized peoples, from the laws of humanity, and from the dictates of public conscience. Various treaties, like the Chemical Weapons Convention and the Biological Weapons Convention, explicitly ban entire categories of arms based on these very principles. So, how do these prohibitions actually work in practice? States have a continuous obligation to review any new weapon, means, or method of warfare they intend to use to determine if its employment would be prohibited by existing international humanitarian law. This means before a new weapon system is adopted, it must undergo a legal assessment to ensure it complies with the principles of distinction, proportionality, and the prohibition of unnecessary suffering. For combatants on the ground, this translates into strict orders and rules of engagement that forbid the deployment or use of any weapon falling under these prohibitions. It is about actively preventing the use of these instruments of war. Specific examples of prohibited weapons clarify these principles. For instance, chemical weapons, like nerve agents or choking agents, are universally banned because they cause widespread, indiscriminate, and excruciating suffering, having little to no military utility that justifies such cruelty. Biological weapons, using toxins or pathogens, are also strictly forbidden for their indiscriminate and uncontrollable nature. Blinding laser weapons, specifically designed to cause permanent blindness, are prohibited because they inflict superfluous injury without serving a legitimate military purpose beyond incapacitating in an inhumane way. Furthermore, certain types of landmines, particularly anti-personnel mines, are heavily regulated or outright banned by treaties like the Ottawa Treaty due to their indiscriminate effect on civilians long after conflicts end. This ongoing legal development shows a clear commitment to limiting the most egregious forms of warfare. Ultimately, the laws prohibiting specific weapons in conflict serve as a vital safeguard, acknowledging that even in the chaos of war, there are limits to permissible violence. They underline a collective global commitment to protecting individuals from the most devastating and inhumane impacts of armed conflict, ensuring that future generations inherit a world where certain tools of destruction remain firmly outside the bounds of legality and morality. These laws are a testament to the enduring effort to instill humanity into the laws of war.